Magandang araw po sa inyong lahat at welcome po sa isa na namang video ng Payo ng Abogado. Para sa module na ito ay pagpapatuloy natin ang talakayan tungkol sa circumstances which mitigate criminal liability. Narito po ang tinalakay natin sa nakaraang module. Module 6, Part 1. At sa pagpapatuloy po ng Module 6 Part 2, i-discuss naman po natin ang iba pang mga sample cases. Sample case number 5, that the act was committed in the immediate vindication of a grave offense to the one committing the felony or delito, his spouse, ascendants, or relatives by affinity within the same degrees. Here is the case. Moises Kapalak was stabbed without provocation by Jimmy Magaso. Magaso, attempting to escape, was confronted by two brothers of Moises, Jesus Kapalak and appellant Mario Kapalak. The attempt of Magaso to board a jeep was unsuccessful. He, having alighted after 2 shots, were fired in succession. Knowing that he was completely at the mercy of the two brothers, he raised his hands as a sign of surrender, but they were not to be appeased. He was pistol whipped by appellant Mario Kapalak, being dealt several blows on the head and the face. After he had fallen to the ground, Jesus Kapalak stabbed the deceased on the chest 3 or 4 times. He was brought to the hospital where he died. The cause, according to the coroner's report, being hemorrhagic shock due to a wound of the heart. Magaso's situation was hopeless. Any defense he could have put up would be futile and unavailing. His hands were raised in surrender. That notwithstanding, he was pistol whipped. When lying prostrate on the ground, he was stabbed. The trial court committed no error then in appreciating the circumstance of treachery as being present. From the above facts of the case, the Honorable Supreme Court held that the mitigating circumstance of immediate vindication of a grave offense should be considered. There is no ambiguity in the language of the revised penal code that the act was committed in the immediate vindication of a grave offense to the one committing the felony or delito, his spouse, ascendants, descendants, legitimate, natural, or adopted brothers or sisters or relatives by affinity within the same degree. What was done was an immediate vindication of the stabbing perpetrated by Magaso on appellant's brother, Moises. Sample case number 6. That of having acted upon an impulse so powerful as naturally to have produced passion or obfuscation. Here's the case. According to the prosecution, Pogay and Panday saw Rodolfo Golane walking about 5 meters away from them with Oliverio trailing behind him. Oliverio allegedly tapped Golane's right shoulder and hacked him on the chest and extremities with a bolo until Golane collapsed on the ground. Pogay heard Oliverio shouting the words, "Patay na ang dato sa barangay San Pablo." The rich man in San Pablo is already dead. Golane managed to tell Oliverio, "Manluba ka man, Ling? Ling, why did you stab me?" After Golane died, Panday proceeded to inform Golane's family of the incident. In his defense, Oliverio alleged that at the time and day of the incident, Golane had been accusing him of having an incestuous relationship with his mother. He allegedly kept his cool and told Golane to go home, but the latter continued to mock him by asking in a loud voice, "How many times did you have sexual intercourse with your mother?" He allegedly asked Golane to go home again, but the latter angrily replied, "Who are you to tell me to go home?" Golane allegedly attempted to draw his bolo, but Oliverio stopped him by drawing his own bolo. They grappled with it, and eventually Oliverio ended up stabbing Golane, which resulted in the latter's death. Accompanied by a barangay tanod, Oliverio went to the municipal hall to surrender to the authorities. He admitted that he stabbed Bolane because he could no longer bear the insulting remarks against him. Here's the ruling. The mitigating circumstance of passion and obfuscation is present in this case. To be able to successfully plead the mitigating circumstance of passion and obfuscation, the accused must be able to prove the following elements. Number one, there be an act, both unlawful and sufficient to produce such a condition of mind. And number two, said act which produced the obfuscation was not far removed from the commission of the crime by a considerable length of time, during which the perpetrator might recover his normal equanimity. In People versus Lobino, it has been held that there is passional obfuscation when the crime was committed due to an uncontrollable burst of passion provoked by prior unjust or improper acts, or due to a legitimate stimulus so powerful as to overcome reason. Let's talk about case number 7, that the offender had voluntarily surrendered himself to a person in authority or his agents, or that he had voluntarily confessed his guilt before the court prior to the presentation of the evidence for the prosecution. There are two mitigating circumstances in this number 7, namely, number 1, the offender voluntarily surrendered himself to a person in authority or his agents. Number 2, the accused voluntarily confessed his guilt before the court prior to the presentation of evidence for the prosecution. Let's talk about the elements of voluntary surrender. For voluntary surrender to be appreciated as a mitigating circumstance, the following elements must be present, to wit: 1. The accused has not been actually arrested. 2. The accused surrenders himself to a person in authority or the latter's agent. And number 3, the surrender is voluntary. The essence of voluntary surrender is spontaneity and the intent of the accused to give himself up and submit himself to the authorities, either because he acknowledges his guilt or he wishes to save the authorities the trouble and expense that may be incurred for his search and capture. Voluntary surrender was appreciated. Upon learning that the court had finally determined the presence of probable cause, and even before the issuance and implementation of the warrant of arrest, Herren already gave himself up, acknowledging his culpability. This was bolstered by his eventual plea of guilt during the arraignment. Thus, the trial court was correct in appreciating the mitigating circumstance of voluntary surrender. The issuance of a warrant of arrest will not automatically make the surrender involuntary. We would like to point out that the mere filing of an information and/or the issuance of a warrant of arrest will not automatically make the surrender involuntary. In People versus Oppo, the court appreciated the mitigating circumstance because immediately upon learning that a warrant for his arrest was issued, and without the same having been served on him, the accused surrendered to the police. Thus, it is clear that, notwithstanding the pendency of a warrant for his arrest, the accused may still be entitled to the mitigating circumstance in case he surrenders, depending on the actual facts surrounding the very act of giving himself up. Let's talk about plea of guilty. Plea of guilty is spontaneous admission of guilt before the trial court, including all the allegations in the criminal complaint or information such as the aggravating circumstances. The admission is voluntary and it is done before the presentation of the evidence for the prosecution. The admission or plea of guilty is not due to force, threat, intimidation, or due to a promise for a price or consideration. While an unqualified plea of guilty is mitigating, it is at the same time constitutes an admission of all the material facts alleged in the information, including the aggravating circumstances therein recited. What are the elements of plea of guilty? Number one, spontaneous admission of guilt before the trial court or in open court. Two, admission is voluntary, that there is no force, threat, intimidation. Also, there should be no promise, price, or consideration to be given in exchange for the admission. 3. Admission is done before the presentation of the evidence by the prosecution. What is the essence of the plea of guilty? The essence of the plea of guilty in a criminal trial is that the accused, on arraignment, admits his guilt freely, voluntarily, and with full knowledge of the consequences and meaning of his act, and with a clear understanding of the precise nature of the crime charged in the information that, when formally entered, such plea is sufficient to sustain a conviction of any offense charged in the information. Plea of guilty is sufficient to sustain conviction. In U.S. versus Burlado, this court affirmed therein accused's conviction for the crime of qualified theft on the strength of his plea of guilty. The court explained that a plea of guilty, when formally entered on arraignment, is sufficient to sustain a conviction of any offense charged in the information without the introduction of further evidence, the defendant himself having supplied the necessary proof by his plea of guilty. The defendant having admitted his guilt of the facts charged in the complaint, the only question left for decision is the penalty. The court, in People v. Santa Rosa, upheld the conviction of the accused for illegal possession of a firearm due to his plea of guilty. It stated that the general rule is that a plea of guilty, when formally entered on arraignment, is sufficient to sustain a conviction of any offense charged in the information without the introduction of further evidence, defendant himself having supplied the necessary proof by his plea of guilty. Not spontaneous plea of guilt. The voluntary plea of guilt entered by the accused is not spontaneous because it was made after his arraignment and only to support his claim of the exempting circumstance of insanity. The voluntary plea of guilt required by law is one that is made by the accused in cognizance of grievous wrong he has committed and must be done as an act of repentance and respect for the law. It is mitigating because it indicated a moral disposition in the accused favorable to his reform. Thank you for finishing this module. There's another one. Let's watch.